Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Okay. Next one, let's go to Cincinnati. This is very recent. Talk about a raw case you pulled off. So this is just a lawsuit because it just the individual was just fired. But in the recently fired Cincinnati fire chief is now sued the city, the mayor, the city manager, and I'll summarize it. But basically what he says is, listen, I had no disciplinary history whatsoever. And he admits that for his first 6 months under the city charter, like most civil service, although this is fire chief, he could be terminated without any cause, for no reason whatsoever. But he says he made it past the 6 months, no disciplinary history whatsoever. He all of a sudden, now there's a new city manager and new personnel who he doesn't think likes him. And all of a sudden, he's now terminated very publicly, which is never a good thing, but he's terminated. And they outline all these things he's done wrong, including working with a women's group who he said he worked great with, and was working with them to address issues, et cetera. And now he's charged with all these complaints, et cetera. Here's the thing. So the city charter states that a non-probationary individual in the fire chief's situation may only be terminated for cause. What it doesn't seem to say, although the lawsuit alleges, is that he wasn't given due process. So what the lawsuit says is, if you look at it under the first cause of action, I believe, it says, listen, he can only be terminated for cause. And since he can only be terminated for cause, he then has a property right, which is not uncommon in being the fire chief. And you can't remove him from being the fire chief without full due process. Notice of charges, right for a hearing, right to present and cross-examine witnesses, etc. So he was given none of this, so he sues. This is not unlike a lot of volunteer suits that we handle, and where the government's required to provide full due process before they terminate you or suspend you long term. So that's really what this is, and it's going to be interesting because Curt, correct me if I'm wrong, this is not the first case that holds if you can only be terminated for a cause that you have to be given a hearing, right? They got
no, absolutely. I think there's a case of, what's it called, Loudermill?
Yeah, Loudermill hearings, right? Exactly.
Yeah, certainly, and it's out of the state of Ohio. Cleveland Board of Education versus Loudermill. Cleveland Board of Education versus Loudermill. So it's right in their backyard. They should know better. But
yeah, and there's an attorney involved, so I don't understand. Maybe not an attorney who didn't know what they were doing, but I don't understand how you terminate anybody without a hearing under that.
I think sometimes attorneys view their roles as facilitators. Okay, they're like, what was that movie, The Accountant? But their job is to get the client's needs accomplished, and if the client's need is to get rid of somebody, then they've got to kind of construct a narrative about we had a legitimate basis, instead of really kind of taking a step back and saying, no, wait a minute, he can only be terminated for cause. So before we do anything, not afterwards, not backfilling the justification after the fact, but going into it, we've got to do an investigation. We've got to present them with the charges, and we got to give them an opportunity to explain a rebut, and then go on with the process, none of which apparently took place. So I predict a settlement.
And the problem for them, because the court is going to say, I do too. The court is going to say you need to go back and give them a hearing, full due process. The problem is, and I don't know how it would work under the city charter, but let's assume that the hearing had to be before a certain board. Well, that board, since they've already terminated him, has unconstitutionally prejudged his guilt. I argue, and many high courts have as well, as you well know, that once the board who's supposed to determine your guilt or innocence has improperly suspended or terminated you, you took your shot. That's it. You can't go back and try to backfill, as you said, or justify what you've done and say, well, now we gave it an unbiased look. No, you didn't. You have to justify why you improperly terminated him in the first instance. And I think that's it.
It's a constitutional right. It's a constitutional right just as much as your Fourth Amendment right. And if the police go in and seize evidence from your home without a search warrant, the remedy for that is not to tell the police, go put it back.
Right.
Okay. You violated their constitutional rights. And so now we've got to look at the remedy for that violation. We're not going to just let you go put whatever it was that you seized back in the person's house and call it even.
Right.
So.
Right. And, unfortunately, the last thing I'll say about this, unfortunate is, New York's highest court and many other states' highest courts all repeat what we've said, right? That this whole unconstitutionally prejudging guilt and you can't go back. But I got to tell you, the lower courts, I'm having a hard time convincing lower courts that that's the law. And so, for example, a fire district, who's the only entity who can determine your guilt, the fire district terminates you, and then the judges are sending it back to the fire district. I'm like, you can't do that. What do you think they're going to say? They're going to say, oh, yeah, we screwed up the process, but our decision was right the first time, because they don't want to get sued for violating your due process rights. I'm having it's a very hard time at lower court levels. And maybe this is what attorneys think. Oh, they'll never figure it out. And look, the chief is probably not protected by the union. I'm assuming he's paying out of his own pocket for this. Yeah. So anyway, it's maybe this was a strategic attempt by the city saying, oh, he'll never sue. But there's another component on this, which is where they should have kept their mouth shut. There's a defamation component where they went out to the public and started accusing him now of what he's never been found guilty of. And boy, you've definitely just sealed your own fate, right? Now you didn't give him a hearing. How are you ever going to? And you took a public position, right? That's the test of prejudging. You took a public position about somebody's guilt. Not only did you terminate him, you put it out in the darn public, right? And told the public he's guilty of what he did. And yet, so now they're really in some hot water. I think they'll be in hot water because this is going to follow the guy around forever. If you terminate someone, you don't say anything, right? Don't defame them. It's a bad practice.